out of a TV set.
Oh, goodness. Well, what a great day for the University of Alabama School of Law. Thank you so much, Justice Sotomayor, for your presence with us today. I will forego the temptation of recounting the incredible morning we've had and the Justice's engagement with students on a number of levels and just your generosity with your time, and just get to the point. So, distinguished guests and students and faculty and supporters, it is my great honor to welcome you to the 2026 Albritton Lecture. Today we are gathered, as I said, for the Albritton Lecture, the brainchild of Judge Harold Albritton, senior judge of the U.S. District Court for the Middle District of Alabama, and a 1960 graduate of our great law school. Over the past 30 years, 12 members of the United States Supreme Court, including our lecturer today, have delivered the Albritton Lecture, and another 3 chief legal officers from 3 foreign countries: Australia, Israel, and Canada. If you're wondering whether that's normal for a law school, the answer is no, it's not normal. And these opportunities are the result in large part of the tireless efforts of Judge Albritton for over 3 decades, and the financial support of the Albritton family for decades before that. We regret that Judge Albritton and Mrs. Jane Albritton are unable to join us today, but we are delighted to have several members of the Albritton family with us. I want to just recognize in particular two of whom are graduates of our law school, Hal Albritton, a graduate in the class of 1985, and Tom Albritton from the class of 1992. You may not know, but Hal and Tom represent the 5th generation of Albritton lawyers. What a legacy for our state, a legacy of service to our state, our profession, and our bar. Would you please join me in thanking them? We are very grateful to have you with us. So now it's my honor to introduce our guest speaker. And I want you to know, I said this to the 1Ls, I'm aware that every moment you hear my voice is a moment you're not hearing hers. That said, I have a problem. It's very difficult to sum up the life and career of Associate Justice Sonia Sotomayor. On one hand, her CV reads just as you would expect a Supreme Court Justice's CV to read. Summa cum laude Princeton graduate, Yale Law School graduate who served on not just 1 but 2 Yale Law Journals, nominated by President George H.W. Bush at the age of 37 to perhaps the most important district court in the United States, the Southern District of New York. Following that, nominated by President Bill Clinton for the U.S. Court of Appeals for the Second Circuit, where she served with distinction for over a decade. And then finally, in 2009, nominated by President Barack Obama to her current position. At the same time, if that background is typical, much of the rest of Justice Sotomayor's story is not typical at all. Justice Sotomayor is the first person of Hispanic descent, and when she was sworn in, only the 3rd woman to serve on the Supreme Court of the United States. Her early childhood years were spent in a housing project in the Bronx, and her parents, both of whom were born in Puerto Rico, spoke Spanish at home. Not only that, when she finished at Yale, she didn't seek a judicial clerkship or take a job at a fancy big law firm. Instead, she worked 80 hours a week in the Manhattan District Attorney's office prosecuting ordinary criminals, and maybe some that weren't quite so ordinary. Even when she took a job with a commercial litigation firm in New York, her practice was unconventional. In her book, she recounts the story of riding on the back of a motorcycle, chasing down high fashion pirates in New York City, or was that the baseball person? Baseball. That was the baseball. All right. So the bulletproof vest was for the Chinese fashion pirates. Yeah, I'm sorry. And her work on the court reflects these experiences. She has been concerned with the way law plays out in the lives of ordinary people in real life. And she's been concerned to be as sure as one can be that these ordinary people are treated with fairness and that our system operates with integrity. I'm looking forward to our conversation today. Justice Sotomayor has a lot to teach us, not only about law, but also about resilience and leadership and success. Not only that, her inspiring story is an exemplar of the richness and beauty, as well as the challenges that accompany the best aspirations of the American project, forging one people out of such plurality and diversity. Not based on ethnic or cultural uniformity, but instead on a shared commitment to liberty and equal justice under law. Justice Sotomayor, it is a great honor to have you with us here as the guest speaker for our 2026 Albritton Lecture. Well, can we welcome her again?
You know, I've had life interfere twice in my coming. One was COVID, where I appeared remotely instead. But I'm so glad, Dean, that you persisted. It's a beautiful law school. For any of you who haven't seen it before, come visit. It's strikingly beautiful. I was told the architect who did the Kennedy Center in Washington did this building as well. But I've been more impressed with your faculty and your students. They are such engaged people. Thank you for the privilege of coming to meet them. And I want to thank the Albritton family. I can't thank you enough for your fifth or sixth generations of support of this law school. And please convey to your father and mother that my deep sorrow that they weren't here, but how glad I am that they sent you as representatives. Thank you.
Thank you. Well, as you all know, the format of this afternoon's lecture is question and answer. And the questions have been submitted previously. I will be reading them and recognizing where possible the authors of the questions.
I have sat through thousands of lectures. Halfway in between, somebody's falling asleep. I prefer this format because I get to answer what you're interested in.
Well, thank you. And let me say, having watched her do this format earlier this morning with our 1Ls, you were in for a treat. All right, let's get started. This is a question from my colleague, Professor Jonathan Arbel. The federal courts have begun experimenting with artificial intelligence in case management, but scholars have proposed more ambitious applications, assisting judges in their in-chamber work, including, for example, the use of AI for so-called generative interpretation as dictionaries of ordinary meaning. Where do you see the line between AI tools that are helpful and those that risk displacing judicial judgment?
That assumes that it's not helpful to have judges substituted. No, look, AI is a sophisticated human. It is, all of its input is input from human beings. And because it is that, it has the potential to perpetuate the very best in us and the very worst in us. Because what goes into computers, if it's bad data, what comes out is bad results, okay? And so it can be a very dangerous tool, particularly in judging the complexity of human endeavors or in human situations. What AI can't do is ask the questions. And that is inherently a danger in any system that you're asking to give answers to. I am told by a colleague that there is a computer system that predicts, in AI, that predicts our Supreme Court decisions, and that it's touting a very high prediction rate. I told him that I thought that was a very bad thing because it shows we're way too predictable. And that we may not be stepping out of our normal thinking and opening our minds to new ideas enough if something like an AI system can actually predict with that high a level of success what the outcome will be. But it will perpetuate the worst in us, and that, I think, is its greatest danger as a tool. We have to employ it with judgment, understanding that there is something to be said about human intuition and something to be said about the human curiosity that lets us see a big picture and figure out what's missing. And that is something that AI is not able to do. And I think if we employ it, whether it's in judges' chambers, in law firms, in law schools, and I think that for every student in this room, do not graduate this institution without learning how to master AI as a tool. I was just at dinner with a bunch of former law clerks, all of whom are very successful partners at a variety of very well-known law firms. And all of them were telling me that all of their associates are expected to use AI. So you can't leave here without mastering it as a tool. But do not believe that it substitutes for our thinking. What it does is put together the way people have thought up to now and give you alternatives, but you still have to make the choices. And people are hiring you to think better than the computer, to think more broadly than it, and to be asking the questions that will lead you to discovery. And so for me, it's a tool we'll have to use. It's a tool that's going to substitute many jobs, not just in the law. Had a conversation with my brother maybe a year and a half ago about how he thought AI would influence the medical profession, and he says, can't substitute for a doctor. The other day, when I got back a lab result that said read by AI, I'm not so sure my brother's right. I don't think any of you in any profession should not be afraid. It is going to be a massive shift in our economy and in everyone's work, because it's going to substitute broad swatches of industries and positions. And so we all have to approach it with some care and wariness. It's not a panacea, but it is an important tool that's going to make and is the new revolution. Just as computers were the revolution of my generation of lawyering, Lexis and Westlaw were just starting when I was in law school. And I was in law school in the 1970s. We're now in the 2020s, and AI is the tool you're going to have to master.
Our second question is from a 3L student, Elena DeFonte.
Hello. We had lunch together.
Her question is, how do you decide to write separately in dissent? And what role do you see dissents playing in the development of law over time?
I had a colleague teacher. I was an adjunct professor when I was on the Court of Appeals in New York. I taught at 2 universities in New York, trial advocacy. My co-teacher used to tell law students that there were 3 questions that they had to answer for anything they did. The first question, and it's the one I asked myself for my dissents, is what is my purpose? What do I want to accomplish by writing this? To do that, I often have to figure out, well, what's my audience? Okay? Who is it that I want to be thinking about what I'm writing? And the question is, why? it's not merely talking to that audience, but is there something that I want to do with what's happening? And the third question is there a better way of accomplishing what I want? And sometimes I have been in a court conference and said, I'm not going to dissent, but I do want to put forth the other argument to all of you because I think there's some strength to it and we should discuss it, okay? But I've made a calculated choice in my mind that a written dissent is not serving a useful purpose, so I don't bother with it, and I'll accede to a majority vote. I'm not giving up my beliefs. I'm just saying that the other side has sufficiently persuasive argument that it's not worth a dissent. When I've elected to write a dissent, it's because there's an audience I want to impact and to think and perhaps to change an outcome that the majority has reached that I think is wrong. Because I only dissent if I think the other guy's got it wrong, okay? But that audience can vary depending on the situation that I'm addressing. Many dissents are for judges in the courts below. They are the Supreme Court upholding a judicial practice or an interpretation of a rule that governs how judges approach a case. And in those cases, I understand that the courts below have a lot of discretion. And so I'm writing to highlight for them other considerations they might bear in mind when they're rendering a decision in a similar case in the future. Issues that I think that the judge who ruled in our case may not have paid enough attention to. So what's my purpose there? To bring forth a different way of thinking of something that other people will think about. And I'm starting and attempting to not influence, but to get people to think about an issue more broadly. Trusting that the effect over time will be that when people have considered something that I've said, it might influence some, and others might come up with better counter arguments to me, all right? Because it doesn't mean I'm necessarily right, but it does mean that I'm troubled by something that should be considered. Then there are the decisions where I'm talking, or not me, me, but others to Congress. There have been dissents that have led to changes in law. The court is saying this is how we read a situation, and this is what we think Congress intended. And a dissent might point out why that intent might not be the one that Congress had, or the outcome might not be what Congress intended. The most famous of those situations is the Betsy Ledbetter case, the one on the Equal Pay Act, where Justice Ginsburg wrote a very powerful dissent where she pointed out it was so unfair to limit the recovery of a woman who didn't know she wasn't paid equally to her male counterpart because her employer was hiding that information for her. And the court ruled that there was only a limited statute of limitations in which she could recover for that unequal pay. And Justice Ginsburg pointed out many things about why that wasn't the fair reading, et cetera, et cetera. But what happened is when the next president came into office, he changed the law. And so there's now a longer statute of limitations, okay? My point is that sometimes you can have that effect. Sometimes the audience is not the federal Congress. It might be a state higher court who is interpreting state law, and you can point out why that interpretation might suffer from some difficulties. And it's a way to have, like I might be doing for a lower court judge in the federal system, to say, maybe the next case you have, you'll think about this, okay? Sometimes it's the people. And it's this is the way the court is interpreting a law. It's not the Constitution. We're the last word on the Constitution, okay? But laws, not only can Congress change, but people can change. And so sometimes my intent is to influence the public to think about the consequences of a law and to get the public engaged in the conversation. And so there's no one audience, but the hope is always to engage people in considering more broadly the questions that are being decided. The one thing that I chafe at is how many people don't read Supreme Court decisions. They read newspaper headlines and decide from the headlines which side they think is right. That's such the wrong way to be an involved and caring citizen. You really have to read the decisions to understand how difficult cases before the Supreme Court are. You know, Supreme Court justices are highly trained lawyers. All of us very successful at our craft. When we're given an opinion to write, we're writing the best opinion just about anybody can to make the best argument, the position we're supporting. It doesn't mean it's right. And it doesn't mean that the issues are that simple. You often have to read the dissents to understand what the majority has glossed over. All right? What wrong step they might have taken. What detour in the law they're creating. There's always things that you need to understand before you accept a court's decision. Well, you have to accept it because you have to follow the law. But I mean, to accept the thinking, you have to think. And you have to be an informed citizen that actually reads our decisions and considers the arguments and considers what role, if any, you should be playing in changing whatever we say. Because you have some role. And so for me, it should be a conversation between the justices and the public.
Thank you. Our next question is from Luke Collins. Luke asks, or says, begins, Ronald Dworkin argued that legal interpretation, this is a question from a 1L. Okay, all right.
Okay, Luke.
Ronald Dworkin argued that legal interpretation is never really neutral, that any method of reading the law embeds deeper moral commitments about people and what they're owed, whether it admits to that or not. Do you think Dworkin was right? And if so, what does that mean for how we should evaluate competing interpretive approaches?
A great Alabaman, Frank Johnson, would tell you it wasn't true. Okay? He's a man who grew up here in Alabama at a time when segregation was deeply embedded. And in belief of the principles of the Constitution, he went against all of the cultural expectations of the time, all of the expectations of probably many members of his family and friends. Many of those Southern judges were ostracized because of their legal positions in many cases. And despite all of that, they still voted to uphold the Constitution and segregate the schools in the South. So we aspire as judges to rise above our prejudices. It's not easy, though. Dworkin was right. Sometimes you don't even know you have them. Often you don't. I have been at hearings with judges who have asked questions where I've known that they just didn't know something, okay? Like at one argument, one of my colleagues asked the defense attorney in front of him, who besides a drug dealer carries two phones? And I'm sitting there and I'm going, the government lawyer who's sitting there. If you're a company or government lawyer, you have to carry two phones because you can't abuse your company phone, okay? My point is that that justice is not biased or prejudiced intentionally, it is that we are, Dworkin was right, we're creatures of what we're taught, we're creatures of the life experiences we have, and those can blind us sometimes to the prejudices we hold because we're not unaware. But that doesn't mean that we can't rise above that. That we can't, on many occasions, put aside those personal beliefs, as did those judges in the 50s, 60s, and 70s, and understand that there are values and principles greater than the ones that we intuitively believe. And so I don't know that I agree fully with him. I do agree, however, that we have to work at it and that we have to be conscious of that in rendering our decisions, that we have to be aware that we are all shackled by our moral compass and its strength and its limitations, because it's developed by societal norms that some are wonderful and some may not be so wonderful. And so our choices can very much be influenced by that. Plessy versus Ferguson was one of those choices.
Thank
But
you.
then 9 extraordinary justices, all men, all white, issued Brown versus Board of Education. They rose above their upbringing.
Thank you. Our next question is from Jake Arnold. How has your time as a trial judge impacted how you evaluate credibility and facts on appeal, especially in closer cases where the facts might support either side?
Who asked that question? I like seeing it. That was you. Hi. I was at lunch one day when I was on the Court of Appeals down in New York, and judges were discussing that question. And I was a district court judge, and I had a colleague there at the time who had been a district court judge and then on the Court of Appeals. But all the district court judges were saying that, judging credibility is a human endeavor, and that it does make a difference in how people testify, their manner of testifying, and that it can and does influence juries all the time. My Court of Appeals colleague said, there's no such thing. It's really given too much credence that you judge credibility by demeanor. You judge people's credibility by whether their story makes sense. You look at all of the evidence, you try to put the puzzle together, and if there are holes, you tend not to disbelieve a person, and if the story holds together, then you believe them. But you rarely, if ever, make a determination, and neither does a jury, merely on credibility, on a judgment about credibility. I look at the person and I believe them. Most of us don't operate in life even that way. When your parents walk into the kitchen and ask who took the cookies from the cookie jar, and all 3 kids are standing there shaking their head, the one with crumbs on their lapel is probably the answer, okay? The point is that I'm not sure that there's an answer to that question. What I am sure of, having done trial work, is that when you are able to judge people, see them, listen to their stories, it makes you more comfortable in the conclusions you're coming to. It helps reinforce conclusions that are very hard. One of the most difficult lessons I learned as a judge, a district court judge, when I handled trials, is I would ask juries, could you be fair and impartial? I never had somebody raise their hand and say, I can't. People don't want to admit they can't be fair. That's just hard to do, all right? So you have to ask them questions that could suggest why they might be biased in one way or another. And how you pose the question is how you can determine whether, contrary to their stated belief, they might not be impartial in this particular case, okay? But my point is that I, for one, do believe that being a trial judge has helped me as an appellate judge immensely, because when you understand that your decisions affect people, I still see the people when I read the transcripts. I don't know how many of my colleagues do. But to me, that's a part of me. And I know just in a recent case, my law clerk had copied sections of a jury voir dire, and I said to the law clerk, no, bring me the full transcript. Because I knew by watching how the questions had developed and what the answers were, how to frame the arguments I thought were more compelling. But my point is, I think being a trial judge is invaluable to appellate judges. If I had my druthers, I would make every appellate judge have trial experience. But it's okay. The ones who don't are all right.
Thank you. Our next question is from Anastasia Sorochinsky. She asks, in recent years, the court has used its emergency docket more frequently for significant rulings. What principles should guide when the court resolves major issues through emergency orders and summary decisions rather than the full merits process? And is the role of the shadow docking evolving? And if so, how should our institutions respond?
Straight out of the news, huh? So for those who don't know enough about the court system, what's the emergency docket? To understand what it is, you have to know what the norms are, okay? And the norm is a case comes to a trial court, a district court. That's the first level of court. That judge hears the case. He hears not just the legal arguments, but develops the facts, because people go to court with different stories, and somebody has to determine what the actionable story is. And by actionable, I mean, which is the story that's going to get legal protection, okay? So the judge has established those facts, heard the law, and given his or her opinion of what the law is. There's going to be a loser. That loser's not going to like it. They have an opportunity to appeal to a higher court. In that process, generally, the procedure is that the judge who got to hear and decide the facts, which are not generally reviewable on appeal. There are some exceptions, but generally not. So the facts have now been decided, okay? And sometimes by a jury. What's going to be reviewed are any errors of law. But a judgment typically will get enforced until a higher court overturns it. Now, the losing party can sometimes post a bond and sort of stay the judgment pending appeal. Or sometimes that losing party can go to the intermediate court and say to that court, this is something that that there was a grave error made below. I will be irreparably harmed if the judgment is enforced. Please hold off. Please stay it pending your consideration of the case. Okay? The Court of Appeals grants it or denies it. If the stay is denied, that losing party has a chance to go to the Supreme Court and make the same argument. This judgment will cause me irreparable harm. This judgment, if you let it go into effect, can't undo the harm to me. And the decision below was egregiously wrong, so you shouldn't let it come about. Until more recent times, the Supreme Court intervened by granting stays or overturning stays very rarely. Why? Because there was I don't know if the word is a protocol, but a belief, an approach to things that said, we're up here. We should be letting the lower courts decide these issues first before we, the highest court of the land, make the final decision. We should make sure that all the facts are fully aired below, that the intermediate courts have looked at this, and we really shouldn't take cases and decide them until there's a circuit split, meaning that circuit courts across the country have disagreed on the answer. Because then we're sure that every viable and important argument has actually been aired, that all the important facts have actually been brought out in the various cases. And since we're the final word, we should do it with some deliberation to make sure we get it right. And so that counseled the Supreme Court for most of its history until more recent times to stay its hand on stays and not to interfere with what was happening with the courts below. And there's a lot of writing that many of us have done about this and about what the rules of review are, et cetera, et cetera. And there's a disagreement among us right now about the efficacy of the emergency docket and of what people have dubbed the shadow docket, okay? But that background is the basis for the disagreement, okay? What has happened? There's been a slight shift in understanding the concept of irreparable harm that has led to a sort of immersion of many emergency applications to the court. There are members of my court who believe, and for their reasons, and I'm not calling them right or wrong or indifferent, I'm not judging them, but who believe that when Congress passes a law, it causes Congress and the people irreparable harm to have that law ignored. And if the president does a policy that the courts are staying, that we're harming the executive irreparably by staying one of those actions until we decide. So that shift in paradigm, where previously we sort of looked at the individual harm versus the systemic harm, if you start with the presumption that there is irreparable harm to one side, then you're going to have more grants of emergency relief because the other side is going to have a much harder time if they're capable at all, if they have individual harm, to win. And so it has changed the paradigm on the court. I think the newspapers are filled with reports about how many emergency motions we are receiving. It's unprecedented in the court's history. We've done it to ourselves. But the point is, I've written that, so I'm not saying something out of school, okay? It is a question, and it's one that we should continue to debate, and we are.
Thank you. Our next question is from 3L Sav Miles. Sav asks, many Americans are troubled by deepening political divisions in our country. As a justice, how do you build bridges across ideological lines with your colleagues on the court?
If you mean bridges, by bridges, convince them that they're wrong? I dissent so much, I'm not very successful. No. You know, my colleagues and I, we're students of the law. We're there because we've shown our deep passion for and engagement with law and with legal theory and legal approach. We've thought and think deeply about the issues who come before us. And on some questions, it's very hard, more so on constitutional questions, to talk people out of an approach that they think is the right approach, okay? That's why the pundits are able often to predict our outcomes, okay? The AI doesn't have a hard job in every case. And it's not that we're stuck in our ways, but because we approach the legal issues in a way that we think is sound for each of us. Now, in every legal approach, there's positive and minus. I'm aware of my minuses, I'm aware of my positives, okay? I hope they are too. But it's going to be hard to bridge that gap. On statutory questions, we do it often. We really talk through a lot of statutory questions because there we're thinking about what Congress might intended. And some of my colleagues say that their number one indicator is the words that Congress use. But words can never be looked at in isolation. You have to look at them in context, and you have to see how they relate to the other words of the statute and to the other provisions. And there could be more grounds for debate on that, okay? But how do we talk? How do we get to a point where I think most of us actually like each other? And we can certainly laugh together. We have lunch together often, after argument and after conferences. You'll see me walking the halls with people with whom I never agree on the court. And we're joking and talking to each other like any other two human beings do. For me, it's because I'm not thinking that how they vote defines them as people or as human beings. I'm looking for the very best in them as human beings. And I'm finding the areas in which we share commonality. Every one of them is devoted to their family and children. Their spouses, their children, their parents, the people that their friends, they are all incredibly loving and giving to those people. Every one of my colleagues has an organization that they've worked with and are devoted to helping. They have institutions that they've been affiliated with that are involved in charitable works that they support. They are people who care. Now, I could say they care about different things than I do. Not really. They may care about different issues than I do, a bit more. But in terms of human values, we share the same ones. And I don't define them by their worst ideas as human beings. I look to them as people to have a relationship with them. And I dare say that with virtually all of them, I certainly have a civil relationship. And with many of them, I think I dare say that I have a friendship.
Our next question is from Sean Dudlani, a 2L student. Sean asks, for law students entering corporate practice, how do you balance the demands of private sector work with the civic obligations you've described in your previous opinions?
I'm so glad you asked that question. At lunchtime, I think I told you, if it wasn't your table, I told another table, that I know so many lawyers in private practice who are rich. I love them. And I'm so proud of them. They make money doing something they love doing, okay? I love what I'm doing, but I'm not rich. But I'm very comfortable. I don't complain, okay? My point is that every one of them who I admire are people who find that balance, who take the wealth of their law firms and insist that all of their associates and themselves devote time to public interest work. Every one of them gives not just legal time, but money to causes they think are important to help the community. Look at the judge here, all right? He was chief judge of a court, and despite that, he's given to this university. It might be because it's a family institution, but the point is that what he's doing is for you, and every penny he gives is to open students' eyes or ears to different ways of thinking of things, and that's valuable for the community. I don't believe that public interest lawyers should count their job as their public interest service. I think they should be involved in activities outside of work, and that's what really counts, because it's not fair when somebody pays you to do good, all right? To count that as being all that valuable. So even when I was a prosecutor, I was involved in organizations outside my work. I didn't get the permission of my boss, but I did. And even in private practice, I did the same. Even today as a justice, I'm here, right? But I go and do speaking to kids of all ages. I've been to Head Start programs. They have no idea who I am. I went to one day. They taught them to perform a play for me, so they must have talked about me, right? I went into their playroom and sat down, and I'm putting together something with one of the kids, and he's reaching behind him to go pick something up, and there's a picture of me on the side of the wall, and he looks at the picture, and he looks at me, he looks at the picture, he looks at me, and he says, "That's you." You know, but if I say or do something that stays with them, it makes a difference. I support, in terms of speaking to their students, a high school mentoring program in Washington, D.C. that mentors kids in how to do well in high school and then go on to college. I did that while I was a judge on the courts below, and continue that kind of work as much as I can. My point is that as busy as you might be in your private life, it should be part of your moral compass that you give back to community. My colleague, Justice Scalia, once said that the greatness of the legal profession is that we are citizen lawyers first. When you think of our founding fathers, more than half were lawyers. That's not accidental, okay? But it's a testament to what the profession draws, which is people who care about community. Because that's what we're doing, is helping people in their relationships with one another. So we have to care about it and give time to it.
Thank you. Our next question is from my colleague Toby Smith, who directs our criminal defense clinic.
They're telling me to talk fast, Toby, up there, so.
The court's application of the Fourth Amendment to contemporary circumstances, seeking to preserve the degree of privacy against government that existed at the time of ratification, contrasts in some respects with the originalist interpretation of other constitutional provisions. Do you see that contrast as an inconsistency, with Fourth Amendment doctrine serving as a model for how other guarantees should apply? Or is the only lesson that the Fourth Amendment uses words whose original meaning is more adaptable to novel applications?
Are you a student or a lawyer already? I'm pausing because the premise of your question is correct, that in this area, we've been asked more to think outside of originalist times because circumstances have changed so much, okay? So I tell kids, all right, the Fourth Amendment says no unreasonable search and seizures, okay? And at the founding, it had to do with going into someone's home and searching their home and their private papers, okay? That principle gets challenged with technology. So what happens when a plane goes overhead and measures the amount of heat being generated from your home to find the level of heat commensurate with marijuana growing underneath the roof? Can the police do that? What happens when you're in your home and no one puts a bug in your apartment, which is the way it used to happen, all right? And we would say that was a trespass and that was unreasonable and illegal. But then the courts had to deal with what happens when you put your ear to the wall and listen to the conversation inside. What happens when some spy network is sitting in a car or a building a mile away and directing radar into your, or something, whatever they do, into your space, wavelengths, and picks up your conversation? And so we moved in the Fourth Amendment early from the concept of trespass, of moving into someone's private space and putting a bug in it or doing something like that, okay, to what is our reasonable expectation of privacy that's being invaded. And so is this space that I'm in, is this activity that I'm doing, something that I have a reasonable expectation will not be interfered with by others? That's not quite how we've dealt with other constitutional rights. I'm explaining your question so I can explain my answer in part, okay? That's not quite how we've approached it, but there have been different theories on the Eighth Amendment, cruel and unusual punishment. In interpreting that, we have also looked to new standards too, unlike what we've done in other constitutional protections. In the Eighth Amendment, even my originalist colleague, and one of its fathers, Justice Scalia, once said that at the founding, they used to execute people by burning them alive. And that today, he probably would find that cruel and unusual. He said that before he died. And he suggested in one speech near the end that he wasn't sure anymore, but I'm going to hold him to his initial gut, okay? My point there is that no, it's not unique to the Fourth Amendment. And in many ways, there are even my most ardent originalists are fighting about what it means. So as you know, with gun control, my colleagues, some of them have adhered towards the obligation that we have to find lawful only those gun control measures that were permissible at the founding. But if you read the writing of my colleagues, some of them have said, who are originalists, so they're not disavowing the theory, that what they're looking at, like the Fourth Amendment, is not an exact historical duplicate, but principles that guided what the founders did, and to apply those principles today. So in answer to your question, I don't think it's completely unique, but I also, and I think it has a lot to inform other areas of law. Since I am much more a justice who believes in the power of precedent as informing decision-making, which originalists tend not to, I do believe that we get informed by the principles over time. I'm just a person that sees how the society and courts have applied those principles and take more lessons from that than some of my colleagues do.
I believe we've got time for one more question, and it will be from Emily Kelly. Emily writes, what advice do you have for younger women who, like many of the students in this school, want to be leaders in their communities and profession?
I talk to anyone who wants to be a leader, and what I tell them is find a passion. The only way you lead people is if you yourself have a passion about your cause. You have to believe in it. You have to believe in its righteousness. And you have to be willing to show how hard you'll work to make that passion a reality. People follow leaders who believe, and leaders who care about what they're doing and the why of it. Women have to find the voice to do that. We as women, you see the men playing sports, how vicious they can be sometimes, but that's their passion in their game. And unfortunately, boys are taught that more because of sports, and a lot of the sports are very physical, like football and stuff, and you can really throw your whole body into that. And so it becomes a little easier for women. For many women, the shyness is hard to overcome. But the way to do it is to not be thinking about you, but be thinking about the issue that's moving you. And letting that issue speak for you. And looking to it as a guiding light that will give you meaning in what you're doing. If you believe, people will follow you. They'll believe too.
What a great way to end this year's Albritton Lecture. Justice Sotomayor, thank you for your wisdom about so many things.